Chris Sontag, who I'm not sure you want. He's a senior vice president and general manager of the licensing division. Is that
overly long title?
And then I just asked, please be respectful in your questions, etc. Let me take the first one over here.
Your talk confuses me. On one hand, you argue that you've got some proprietary technology that's copyright that was stolen, and that's perfectly reasonable. And then the rest of it seems to be this FUD talk, which I get the impression free software is bad and shouldn't be allowed, is the message I get from what I hear here and what you've said elsewhere. And I don't understand that. I mean, that's sort of like saying you should only be allowed to sell music and nobody could put a song out for free. Am I misunderstanding what you're saying?
You bring up a good point, which is I'm not saying it's bad for someone to contribute their works. Okay? I'm saying it's bad for someone to contribute my works and say, I'm going to commoditize and destroy your business against my will. I am not saying, when I said I respect Stallman, I believe that Stallman would be horrified if this thing comes out that property that is protected is showing up as part of GNU/Linux. Okay? I believe that at a voluntary level, anybody that wants to contribute, if IBM wants to put Informix in there, if they want to put anything in there, okay, that doesn't violate my rights, God bless them. Ourselves as a company, we've put things in there. Okay? Those are not the things we're arguing about. But I do believe that as a society, we're on a very slippery slope right now if we move down this path of saying, let's all jump on the software is free and software is good movement, and let's just make all software free, because I have had my eyes opened in the last year or so that I think that is a slippery slope and it doesn't have a good destination.
Got to use this newfangled technology here. So my name's Eric Jonas, and I'm a student at MIT. And in fact, my friends here, we're also all MIT students, and we're essentially engineers and scientists. So intellectual property is extremely important to us, because this is all we're ever going to do with our lives, right? So what I don't understand, well, first of all, in our own act of civil disobedience, you mentioned people copying Linux many times. We actually gave out copies of Linux to everyone in the audience today. If you didn't get a copy, feel free to see me afterwards, because we truly believe that the intellectual property foundations of GNU and the GPL are very strong. But amongst the millions of questions I'd like to ask you, my number one is, you've been telling people that you believe that your intellectual property has been contributed to the Linux kernel all night. This seems to be the most substantial portion of your talk. But I'm curious if the code is already out there, if in fact I have a copy of the Linux 2.6 kernel right here in my hands, what do you have to lose by telling people, well, these are exactly the parts that are infringing? Because as I understand it, and in fact Linus Torvalds has said himself, you guys refuse to tell people, except under NDA, which portions you believe are infringing. And now I'm not a lawyer, but I know that if someone was doing something that I felt was harming my rights, I'd try and stop it as quickly as possible.
So let me take a first shot at that, and Chris, if you want to follow up.
Sure.
Has SCO shown the code? Okay, first of all, SCO owns intellectual property at System 5 level. When we say we've licensed this thing 6,000 times, we've licensed it, and people are under very tight restrictions about not being able to show that. If we go out and just throw it out in the public, we are basically violating our own commitments we have with our licensees. Now, with respect to code that we have shown, let's follow the bouncing ball here for a moment. Last summer, we came out with code that was very clearly replicated and showed that last August. It was done under NDA because we didn't want to violate our own agreements. A number of people saw it, and shortly after that, a Linux leader, in fact Linus, came out and said that code has been removed from Linux. We then had some other code that tied to it that Silicon Graphics came out and said that was System 5 base code. It wasn't supposed to be in there. We took it out. Okay? So there's two occasions. Now, again, SCO said it was in there, wasn't supposed to be in there. They took it out. Now, they didn't take it out of the thousands and millions of servers running around the world. So even at that level, you still have an infringement problem. But they did take it out of future versions. We then said there is roughly 1 million lines of code tied into contributions that IBM has made, and that's subject to litigation that is going on. we have basically supplied that. In fact, that is going to be the subject of a hearing that comes up this Friday in the Utah courtroom. We have supplied them with ample evidence in terms of where those infringements came from. And then finally, a month ago, we came out, or December, I guess it was, we published 75 header files that showed up inside of Linux that tied to not just our intellectual property agreements, but to the BSD settlement agreement from back in the 90s. And the settlement agreement says, what does it say, Chris?
It says basically that there's a set of files that had to be removed from BSD. There was a set of files for which copyright attributions to AT&T, USL, and effectively SCO had to be placed on all those files. And there was another set of files for which there was no issue. Those files that were, had to have the copyright attributions, portions of those files ended up in Linux, which is a problem. Which means we have copyrighted work that was part of a court-approved settlement that have ended up in Linux inappropriately, and we haven't seen any action to correct that problem yet.
We did send out letters notifying people that we were, to your point, we did send out letters in December. We said we are concerned about this, and the deadline for responding to that was Saturday. So if you look at when we say we're moving down the path of litigation, we are doing things to try and mitigate. We are trying things to try and get things resolved, and we'll see how that plays out.
There's a button on the bottom you can press.
Sorry, I've never been here before. Hi, I'm very concerned about the argument you're making against free software, because the reason free software is so valuable is because it provides the basis, the substrate upon which other software, whether free or proprietary, is built on. And it seems to me that by creating fear, uncertainty, and doubt in the filing of your lawsuit, you are doing the opposite of promoting the sciences and useful arts. You are trying to undercut the basis upon which much science and useful art is being built. Furthermore, you're not the author of Unix, you're not the developer of Unix, your company had nothing to do with creating Unix, so why should anybody in this room support what you're doing?
Any contract lawyers in here? Again, if you
Not
go
yet.
back,
Not yet. Okay.
if you go back and read very clearly the contracts, did Chris or I develop Unix? No. Dennis Ritchie and Ken Thompson did.
And many others.
Yeah, and so from the latest copyright legislation out there, those copyrights are good for 70 years of the life of 70 years plus the life of the inventor, and we're sending those guys vitamins and spa treatments every day. No, we didn't create them, but we paid millions and millions of dollars to acquire them. From a contract standpoint, there has to be some meaning assigned to a piece of paper you have that you paid millions of dollars for that says you own all right, title, and interest in Unix. It says those words, okay? From a standpoint of your first argument, which is the free software side of it, we're fine with free software. We're not fine with somebody taking our proprietary software and making it free. That's all we're trying to say.
Let me just add one thing, 2 points to that. One is in terms of free software. The concern is with the extremes. If we're going to end up as a society, a world society, where the extreme of all software must be free, we view that as being problematic. The second point is in terms of ownership rights. Most of us here probably didn't build our house or build the apartment that we live in, yet we still have rights in terms of that property. So the fact that Darl or I didn't code Unix is immaterial. The fact is that we've purchased that house, we've purchased those rights, and we have the right title and interest in that business. And so ownership is important. Property rights are important. We're talking about software that's somewhat intangible right now, but ultimately we're talking about an issue that can be stretched to all sorts of other things. Your right of your ownership of your iPod. Can I just walk up to you and take it away from you? What is my right? I want it, so I should be able to take it. How far do we stretch these issues? Right now we're dealing with software or music or with a play. But at some point we're talking about physical property rights. And at what point is, society's rights, individual rights balanced? And that's what we're dealing with, and we're trying to deal with it in the court system and not deal with it in terms of being beat up in a web attack or other things.